Hi, my name is Stacy Maurier, and I'm the founding lawyer of Estate Connection Law Office in St. Albert, Alberta. One of the big stumbling blocks for many couples in writing their will is who is going to be the guardian of their children if something should happen to them. So, in most situations, if you have a couple and they're both parents of the children, if one of the parents dies, the surviving parent, as long as they are the parent of the child, will become the guardian. But what happens if both of them pass away? Who will take over and handle the raising of the child? And usually this is what stops people from writing a will is because of this guardianship stumbling block. So you have a couple options when you're looking at appointing a guardian in your will. When you're looking at who to appoint, I would be thinking of who is closest to you, both in relationship and geography. So, for instance, if you had maybe a sibling in Edmonton and a sibling in Calgary, they're both fairly close, but you have to think about whether your child would want to be uprooted and move to Calgary if you're looking at appointing that person. Now, it gets even more complicated if we're talking about moving people out of the country. Maybe you're a doctor from South Africa, and if something happens to you, you want your children to go back home to South Africa. Well, after your kids have spent 10 years in Canada, it could be a really rude awakening for them to go there. So it may not be the best decision. So look at who is closest to you and who has the same morals and values as you. And when you're looking at a guardian, it doesn't necessarily have to be family. Sometimes it's friends, sometimes it's neighbors, it's people that you're close to, not necessarily family. However, if you and your spouse are fighting and bickering over who can be the guardian of the children, well, you have a couple options. And what I suggest is either A, we appoint both persons to be the guardian, and then they can work together and decide and determine what's best for the child. And from my experience, sometimes what ends up happening, especially if children are older, is they end up going to boarding schools, which, good boarding schools. We're not talking residential schools here. We're talking but good boarding schools where there's kids from ambassadors and the well off. And then those kids come home on the breaks. And, it's good for the kids. They get a good education. They don't have to feel like they're a burden or trying to infiltrate another family, and the guardians don't have to worry about the day-to-day care. So that is one option. And if you don't like that, another thing you can consider is appointing the guardians as off year. So it's not the best, but if this is going to help you write a will, in odd years, if you die, we could say it's going to be B, and in even years, if you die, it's going to be party A. And so it's just random what the universe decides for you, but at least this way you're writing a will. And honestly, don't let this be a stumbling block for you. I would rather see you write a will, even without a guardian in it, and at least have a will where your children's money is protected. If you don't write a will, your children will inherit their money in Alberta on their 18th birthday. And for some of you, if you have insurance through your employer, life insurance, maybe you have a home, you have some, trailers and quads, your kids can be getting hundreds of thousands of dollars on their 18th birthday. And for many of them, they won't have that money on their 19th birthday. I once had an estate where a kid inherited money on his 18th birthday, and all the GICs came due on his birthday except for one, which was about 10 days later. And you think, oh, well, who can spend 140 grand in 10 days? He managed to. He bought several cars, even though he didn't have a driver's license, and he needed that money that was sitting there in that GIC. So write a will so that at least you can have the money in trust. And be aware that at the end of the day, who you've appointed, if they don't take on the job, well, it'll ultimately be the courts that make the decision. So you can write a document without someone being appointed, because even if you appoint someone that no one likes, the courts can overrule it. So, for instance, if you decide that Omar Gaddafi would be a great guardian for your children, courts could look at it and say, you know what, that's a little bit crazy. And so we don't agree with that, and we're going to override it. The other thing to be aware of is if you're in a second relationship or maybe you have children from different spouses, is the spouse you live with now can't automatically be the guardian of that child if they're not the parent of that child. So it may be a situation where while you're alive now, you might want your current spouse to adopt your child so that they do have that legal requirement and would be the guardian if something should happen to you. This is a confusing area of the law, and I know many of you struggle with it, but I don't want this to stop you from writing a will. If you have questions or concerns about who should be your child's guardian, contact our office. We have a handout that you can work through that we provide to all our clients that kind of guides you and indicates, who would be the right guardian for your children. Questions, call us. We're here to help.